Hey Andrew, can you tell me more about accessing my electronic health record?
Sure. Uh, for over a decade now, uh, medical records at hospitals and doctors' offices have all been required by federal law to be digitized, meaning that there's a digital or online record that's available to patients as opposed to the old handwritten chart with non-carbon reproducing copies and things of that nature. So everything goes into the computer now. People probably have noticed that when they go to the doctor, a lot of times the doctor will be sitting there and they'll be punching away at the keyboard, entering information. Sometimes doctors have scribes who record that information so that the doctor actually gets an opportunity to listen to you. And that unfortunately that's just the way it is right now. And we often need our medical records. We refer to them as EMRs, electronic medical records, and they're very important for any kind of personal injury lawsuit, and they're of particular importance in a medical malpractice case. Now, there are good sides and bad sides to having everything in an EMR. The first downside, is a lot of it is automatically populated by the electronic medical record itself. There are pull downs that are available to the person putting the information in, where he just clicks on the tab, clicks on the box, and the information is automatically put into your record. This may or may not be accurate. That's why they are required to maintain things called audit trails, which allow you to see who accesses your record and what information is being put into your record. Now, you don't actually get a chance to look at the screen. In order to look at the screen, you've got to actually go to the facility and look at their computer, look at the interface, and see what the pull down tabs are. But I'm getting a bit off on a tangent here because I want to talk about getting your records, because getting your records are important. And a lot of times, individuals, patients, will need to get their own records, both because they want to have them for safekeeping and also because their attorney will need it. Now, there are three main statutes that are going to cover requesting medical records. And I'm just going to give you the acronyms because that's the way everybody refers to them these days. The first is something called HIPAA, which a lot of people may be familiar with because you're always signing HIPAA authorizations when you go to the doctor's office. The second one is something called HITECH, and the third is a newer one called the Cures Act. Now, taken all together, what do they do? Well, HIPAA gives you a right to get to your medical records. And it's not just the record itself, it's also your billing and associated information. Now, it can be given to you in different forms. The hospital, for instance, may create a portal, and the patient can access their records on the portal. The portal does not necessarily have to contain all of your records. It's only required to maintain a designated record set. But you do have the right to request your complete chart, which could be quite large. The reason why is because electronic medical records tend to duplicate themselves over and over again. So a short stay in a hospital of only, let's say 3 to 5 days could easily generate 1,000 pages of medical records. Now, because they're digital, they can also be searched quite easily with various programs, such as with Acrobat or other PDF search programs. And that way you can get through your record pretty easily. But the problem is if you retain a lawyer because you've been involved in an accident or if you have a medical malpractice case, if your lawyer requests those records, they could be very expensive and expensive unnecessarily. Uh, Many states, specifically Florida, where I practice, hospitals can charge $1 a page for your medical records. Now, typically, they outsource the maintenance of the records and supplying the records to other companies such as Ciox ShareFile. There are other various companies that do this sort of work. Ciox is the one that immediately comes to mind. Now, what do? You request your record. They send you usually a pre-bill that says you've got 1,000 pages of records and you're going to owe us $1,000 to get those records. Now, that's the price that your lawyer would pay if your lawyer requests them. If you request them through what's called a personal patient request, you can get them for a very small fee, usually $6.50. It can be more. The law allows them to charge the actual cost of reproducing the records. But if they do that, they have to itemize everything and account for everything that they're charging you. And so most hospitals will find it easier just to charge you the flat rate of $6.50 to obtain your record. Now, the record can be obtained either through a download, through a file sharing program, or it can be requested as a paper record, or it can be requested as on a USB drive or on a CD or DVD disc. You can go to the hospital itself, to the medical records department, and make that request in person, and they will usually either give you a USB flash drive or a CD or DVD, and you'll take that with you. Now, it's much more convenient for the lawyer to request those records. But unfortunately, Ciox, for instance, realized that they were losing a fortune if they couldn't charge $1 a page. If they could get a chart and charge you $1,000, they could now only charge $6.50. And so they challenged this. And in a case that was decided out of a Washington, United States Court of Appeals case in the DC Circuit, in a case called Ciox versus Azar, the court held that a patient request can be made and the charge is $6.50. But if the request is made by an agent, such as your lawyer or representative, they can charge $1 a page. So how do we handle that? The way we handle it as a law firm is we have our clients submit personal requests that we assist them in generating, meaning we may create it and send it to them to forward on to the hospital. And once the patient request is made, those records have to be provided in a digital format for usually $6.50. Now, how soon do they have to be provided? They have to be provided within 30 days under the federal statute. Although in Florida, because we require pre-suit screening of all medical malpractice cases, there is a 10 business day requirement for them to provide the records. If they don't provide the records within 10 business days, then there are waivers of certain specific entitlements that they have under the pre-suit screening statutes. So usually when that patient request is made, if they don't think there's a lawsuit involved, they may take the full 30 days, which actually will work to your favor because they're going to be in violation of Florida's pre-suit screening laws, which are contained in Chapter 766. If they don't produce the records, then what we do is we then send a letter stating that we are representing you in your request for the records, not our request, but your request. In that way, it's somewhat of a workaround, and we're able to get the records on your behalf. But the initial request needs to be made by the patient. Now, what type of information is contained in there? Well, basically, it should be your entire medical chart. And that has to be provided to you upon your request. Frequently, you don't get the whole chart. You may have to request your records 2 or 3 times, maybe more, before you get everything. At that point, usually your attorney will be assisting you in getting those records. But your electronic medical record is the key to be able to prove your damages, if it's just a general negligence case. And in the case of a medical malpractice case, it's the key to being able to prove the liability of the healthcare provider, meaning the hospital or the doctor, and the damages that may accrue from your treatment or the malpractice. You can require a summary. Okay, they can provide you with a summary, but the summary can only be provided with your consent. So if you don't consent to a summary, they've got to give you the whole chart. There are penalties that can be imposed if they don't provide the appropriate records at the appropriate fees. You can file a complaint with the office of with the United States Department of Health and Human Services. They have a civil rights enforcement. This is considered civil rights enforcement at HHS. There are forms that are available for that. And I can't tell you that it's going to be effective, but usually if you file a complaint with the Department of Health and Human Services, it usually gets a response from the healthcare provider before the United States Department of Health and Human Services has to respond. So that's one way that you can enforce the rights of your for these records. They have no right to deny you your records, and they can, however, require that certain verification be provided, such as a driver's license or other evidence that you are who you are, or your relationship with the patient. Now, they have to provide records to a surviving spouse in the case of a medical malpractice case, or to parents. However, they can require that there be verification of your status. So what often happens is that you'll need to provide a death certificate, which may indicate your spousal status, or a marriage certificate, which likewise indicates your spousal status, perhaps a birth certificate in the case of requesting records for a child. It's not universally required from all healthcare providers, but it seems like it's being done with greater frequency. So be prepared to have that kind of documentation to verify who you are. But once you provide them with that information, they are required to give it to you. And they're required to give it to you at that minimal cost of usually $6.50. So that basically is how you go about getting your electronic medical record. And just to summarize it very quickly, you can go in person to the medical records department and make that request as the patient, or you can submit that request online or via fax or via letter that you submit as a personal request, not a lawyer's request, but a personal request. And once they get that, they have to provide you with your records. So I hope this has been somewhat educational. It's actually a rather complex area, and there can be a lot of little nuances to how you go about doing it, but that's basically how you would go about getting your medical record. Now, from the standpoint of being an attorney, when the client or the potential client has their records in tow when they come and speak to me, it makes it much easier to evaluate whether it's a case that we would be interested in pursuing or not. So that's it for today on how to get your electronic medical records.